Here is a situation that some employees who are union members face. An employee is terminated and he goes to his union and he files a grievance, and his shop steward or somebody else at the union tells him that he should not be filing a lawsuit in court until the grievance, the union grievance, is resolved. So the employee follows that advice and he waits for the union to do something, and the union is not doing anything for a long time. The employee keeps calling them and following up. Nothing seems to be happening, and eventually the grievance gets dropped because the union decides not to pursue it any longer for whatever reason, and they're perfectly allowed to do that in the vast majority of cases. Or the grievance does go all the way to arbitration and the employee loses the arbitration. In any event, regardless of where it goes, the process takes longer than a year. By that time, when it's more than a year after that employee's termination, he can no longer file a discrimination, retaliation, and many other kinds of wrongful termination lawsuits in court if he or she didn't file a charge of discrimination with EEOC or DFEH, which is Department of Fair Employment and Housing, within 1 year of termination. So, what is the lesson from this? The lesson is not to listen to the advice of your union shop steward or somebody else who tells you that you should not go to DFEH or EEOC or to court before your grievance is resolved. You have nothing to lose, and it will not harm you to file a charge of discrimination with DFEH or EEOC if you have legitimate grounds to suspect that you've been discriminated because of your religion, your disability, your race, your ethnic origin, or for any other reason, or if you feel you've been retaliated and your situation falls within one of the protected activities. The moment you file a charge, all the deadlines stop running until you get your right to sue letter, and from that date you will have 1 year to bring a lawsuit for wrongful termination in court, and that's regardless of how your grievance and how your arbitration through the union goes. Even if you lose your grievance or you lose your arbitration, you might still have a viable wrongful termination case, and if you win in the arbitration, then you can decide whether you want to pursue a wrongful termination claim and whether it makes sense, and you can consult a knowledgeable employment attorney in your area who can look at all the facts and all the circumstances of your termination, of your grievance, of your discrimination allegations, and decide what's the best practical and legal way to approach your situation if you have two things go at the same time: the union grievance and a possible case in court. And in many cases, having two actions go at the same time, one through the union and one through court, can be beneficial for strategic reasons, because this applies more pressure on the employer. It forces them to spend more money and take your claims more seriously. It will also encourage them to try to reach some kind of global settlement with you, where all your claims will be settled for a certain amount of compensation or reinstatement or other benefits.